Hello friends, in my last video I did share the journey of my becoming successful author, but in this video I would like to share an overview of the Indian Contract Act 1872. Indian Contract Act 1872 is a very important part of the mercantile law or commercial laws. ICA, before the enactment of reorganization of Jammu and Kashmir Act, it was applicable to the whole of India, excluding the state of Jammu and Kashmir. But after the enactment of Jammu and Kashmir Reorganization Act, now it applies to the whole of India, including the state of Jammu and Kashmir. This J&K Reorganization Bill was placed in the Rajya Sabha on 5th of August and it was passed on the same day. And it was placed in the Lok Sabha on 6th of August and got passed on 6th of August itself. But the president gave his assent on 9th of August and with effect from 31st October 2019, it has been made applicable to whole of India, including the state of Jammu and Kashmir. The Indian Contract Act 1872 has been divided into two parts. Part 1 comprises of sections 1 to 75, deals with the general principles of law, and Part 2 comprises of sections 124 to 238, deals with the special contracts, contract of indemnity and guarantee, contract of bailment and pledge, and the third one is contract of agency. Now in this video, I would like to give you an overview of Indian Contract Act 1872. Indian Contract Act 1872 has been covered in 10 chapters. The very first chapter is nature, meaning, essentials and kinds of contract. In this chapter, you are going to study the meaning of contract, what is an agreement, what is a contract, and then how the agreement is different from contract. And then what are the essentials of valid contract? What are the kinds of contract? Because there are various bases on which we can classify the contracts. On the basis of enforceability, on the basis of extent of execution, and then how can the contract is be created on the basis of mode of creation. And after that, you are going to study how how is agreement term different from contract. What are the distinctions between void agreement and voidable contract? And what are the various points of distinction between void agreement and illegal agreement? So these are the various headings which you will like to study or learn in the very first chapter. And the second chapter will be offer and acceptance. The term agreement is a sum total of offer and acceptance. What is offer? What is acceptance? What constitutes valid offer? What constitutes valid acceptance? And then what are the rules regarding communication and revocation of offer and acceptance? And can offer be revoked or can acceptance be revoked? What is the time limit within which offer or acceptance be revoked? Then third chapter will be the consideration. Consideration is a technical term which is used in the sense of quid pro quo, which means something in return. Not only consideration should be there, but consideration should also be lawful. Any agreement which is made without consideration is not valid, it is void. But there are certain exceptional cases where this rule is not applicable. That is, an agreement which is made in the absence of consideration is not void, it is valid. And then a stranger to the contract cannot sue on the contract. Stranger means a person who is not a party to the contract cannot sue on the contract. But again, there are some exceptional cases where a stranger to the contract can also sue on the contract. Then the fourth chapter will be competency of the parties to contract. Everybody is not competent to contract. No, capacity of the parties has been defined under section 11. Every minor person, every person of unsound mind, and every person who has been declared as disqualified under the law is incompetent to contract. So, in other words, we can say every major person, every person of sound mind, and every person who has not been declared as disqualified under the law to which he is subject, they are competent to contract. Then you will study the laws relating to minus agreements. Then, what is sound mind? What is unsound mind? And then, which are the persons who have been put under the categories of disqualified persons? Chapter number 5 will be free consent. What is consent? Two or more persons are said to consent when they agree upon the same thing in the same sense. Not only consent should be there, but consent should also be free one. Now, consent is said to be free as per section 14 when it is not caused by coercion, undue influence, fraud, and misrepresentation. So, the resulting agreement becomes wordable contract. So, under this chapter 5, free consent, you will study in detail coercion, difference between coercion and undue influence, difference between fraud and misrepresentation, and the types of mistake. Now, coming to chapter number 6, which is legality of object and consideration. Now, how can we say the objective is illegal? What is illegal agreement? And which agreements have been regarded as opposed to public policy? There are 10 points, 10 agreements which have been held to be against the interest of the public, or they have been regarded as opposed to public policy. Then chapter number 7. Now one of the chapter number 7 is void agreements. One of the essentials of valid contract is that agreement should not have been void expressly declared as void under the law. So long list is given. About 6 to 7 points are given under this chapter which have been expressly regarded as void. Like agreement in restraint of marriage, agreement in restraint of trade, agreements in restraint of legal proceedings, etc., etc. And then chapter number 8, which is regarding discharge of a contract. Now, discharge of a contract means when the rights and obligations under the contract are extinguished, then the contract is said to be discharged. There are a number of ways in which contract may be discharged. Broadly speaking, there are 6 modes of discharge of a contract. The very first one is friends by performance. Second is by agreement. Third is by impossibility of performance. Fourth is by operation of law. Fifth one is by lapse of time, and the last one is by breach of contract. So under this 8th chapter, you will study how can the contract be discharged, or which are the ways in which contract will come to an end. And then chapter number 9 would be quasi contracts, or certain relations resembling with those created by contracts, or quasi contractual obligations. Friends, these are the obligations which have been explained under section 68 to 72 of ICA 1872, and these obligations have been created by the law. There is no offer, there is no acceptance. These obligations created by the law, they are enforceable even if there is no offer and there is no acceptance. So these obligations created by the law, they are known as quasi contracts, and they are based upon the principle of unjust enrichment, which means no one is allowed to enrich himself at the expense of another. And then chapter number 10 will be remedies in case of breach of contract. Every contract gives rise to rights and obligations. If both the parties to the contract perform their obligations, then the contract comes to an end. But what happens if either party to the contract, commits breach of contract? Breach means non-fulfillment of the respective obligation under the contract. That is, one party to the contract commits, does not fulfill his part of obligation. Then we say breach has occurred. So what remedies are available to the injured party? Then there are two parties involved. One is the sufferer party, other is the guilty party. What rights are available to the sufferer party or injured party, or we may call aggrieved party, against the guilty party? First is the right to claim damages. Second is right of rescission. Third is right to sue upon quantum merit, which is proportionate payment or pro rata payment. And then fourth will be right to demand specific performance of contract. Specific performance means carrying out the actual obligation of the contract. And the last is right to bring injunction order from the court. Injunction order is a prohibitory order which is, granted by the court where the contract is of personal nature. So, friends, I have covered the entire overview of ICA 1872 in this video. I hope you will like this video, and do not forget to like my video and subscribe to the channel and press on the bell icon, because you will be receiving all notifications when you press the bell icon. So friends, I tell you that I'll be giving you more videos. The entire syllabus of BCom Honors Semester 1 I would like to cover in my videos. Okay friends, goodbye. See you again.